Yes, sir.
All right, I wanted to, first of all, thank you guys all for coming to the CLE today. I wanted to welcome you on behalf of Alex Bundin, the Public Defender's Office. I wanted to welcome you all here today as we began looking at different trial skills. And we're going to start off with our little session, our seminars, series of seminars on trial skills, addressing closing arguments. And before I do that, I want to at least make some brief announcements. April 30th of 2016 will mark the 30th anniversary of Batson versus Kentucky, of the Supreme Court's decision in Batson versus Kentucky. Until that end, on April 27th, the Harris County Public Defender's Office is going to be putting on the CLE in regards to Batson and Batson challenges, and evaluating and looking at Batson 30 years out. And I also wanted to make an announcement. It's been called to my attention that there are two other CLEs coming up. One by the Trial Lawyers College, which is being held in Hunt, Texas, outside of San Antonio, from April 14th through April 17th. It's a 4-day CLE, and they say that they have scholarships and all available for criminal defense lawyers. If anybody's interested in that, I can give you additional information during a break. And then also HCCLA is having a CLE in April in regards to error preservation. And so those are some CLEs that are available. If anybody's interested or wants additional information about those, I have some over on the side. Closing arguments. I think most of us can agree that oftentimes other aspects of a trial might get more attention than closing arguments. Voir dire, some think, is the most important part of a trial, because if I've got 5 people on the jury who are definitely going to convict the defendant, then my chances are a lot less than if I have 12 neutral people on the jury. So picking the jury is relatively important. Some think cross-examination is more important because you can fashion your case through cross-examination. It's a tool the criminal defense lawyer uses in cross-examining witnesses. But closing argument is the aspect of the trial that everything comes together. And we have 4 people who've agreed to come and talk about closing argument and to demonstrate a segment of a closing argument. And the first person, I have the pleasure of introducing those 4 people, and the first person up is Judge Stacey Bond. I don't know if any of you have ever seen Judge Stacey Bond try a case, but maybe about 5 years ago I saw Judge Bond try a case in the 184. And I didn't know who she was, but I was impressed with her as a trial lawyer because she was a lawyer. And I watched her do a closing argument in a case, and I think it was a child injury case that she did a closing argument in. And her client was acquitted in that case. And I remember her fashioning her argument about reasonable doubt better than I had seen other lawyers do. She argued reasonable doubt and made it tangible for the jury so that the jury could understand it and be able to relate to it. And I thought after watching her that she had something to teach, that she had something to teach about closing argument. So when we were doing CLEs for lawyers, I wanted to ask Stacey Bond as a lawyer, but she ended up running for judge and being elected for judge. And someone told me that even though she's a judge, you still should ask her. And I did, and she graciously agreed to teach on the CLE on closing argument. And so without any further talking from me, I want to at least bring up Judge Stacey Bond.
Am I good? Hello? Can you hear me? A little bit? Oh, there you can now. All right. Good morning. Afternoon. Sorry. So I recognize lots of you. I got to tell you, I'm extremely nervous. It's been a really long time since I had to prepare for closing argument other than asking if the state's ready to proceed. But I appreciate very much your attendance, and I have a few things to say that may or may not be helpful, but I will tell you that I'm speaking to you as Stacey Bond, the former advocate, and based on how things go in November, I may be right back at you being an advocate again. But I'm not talking to you about my opinions or the way I think that you should argue your case when you're in my court. I'm telling you or talking to you about things that I've used or things that I've seen that I think work. I will tell you that now that I sit facing the wrong direction, I have seen some outstanding lawyers. I've seen some great closing arguments. I've seen plenty of things that I wanted to emulate. And I've seen some things that I thought could be done better. The first point that I'd like to make, and I think this is self-evident, is that the time to prepare for a closing argument is long before you set your case for trial. One tip I have for those of you that are defense lawyers, especially young ones, because the old guys know this, gals. Don't use your best argument on the prosecutor. Don't share the clincher with the state of Texas. If you've got a great argument, don't share it with the prosecutor so they can fix it. Don't share it with the prosecutor so that you can lose that argument when it comes time to argue to the jury. All right? Now, if it's an alibi and the state can't beat it, maybe you tell the prosecutor. If you're young, then talk to some old guys that know the prosecutor you're dealing with. The DA's office is way different than it used to be. But now, and my experience as a defense lawyer, is that you must hold your cards closely if it's in the best interest of your client. Sometimes it's not in the best interest of your client. Depending on what court you're in, your client may have to wait years before they get to trial. So talk with your client about whether or not they want you to divulge to the state of Texas what their defense is before you do it. And even still, if that's what you're doing, tread lightly and document it. Okay? Don't use your best argument. Now, when you set your case for trial, think about what you need in your trial, what you want to argue. You set cases for trial for all sorts of reasons. Occasionally, you have an innocent client. I practiced law for 20 years. I had about 5 who were actually innocent. All right? Now, I had plenty more where the state of Texas couldn't prove their case. Right? You argue those almost the same way. The pressure feels a little bit different. Sometimes you set cases for trial because you and the state can't come to an agreement about punishment. Sometimes state of Texas has overcharged their case. Sometimes your client's unreasonable and demands their trial. Right? If that's the case, you still have to prepare. You still have to think about what it is that you want to argue. But you're thinking more about punishment there. But prepare that closing argument in your mind. When that case gets set for trial, think about what the charge will say, what you will have to work with in the charge. If you're a younger lawyer, don't know what that charge will look like, ask one of the old guys. The thing about, and I mean gals too, the thing about defense lawyers is that they want to help you. They're fighters, and everyone loves a good fight, right? They will help you. I never, ever one time asked for help from any defense lawyer that they didn't say, tell me about your case, what you got going on, this is how it works. That's why these CLEs, these groups, HCCLA, it's why it's so helpful. Figure out what the charge is going to read. Think about what you want to argue. Make a list. You know how the prosecutors, if you weren't a prosecutor, you know how they write down their elements and then they check them off as they go? You need to do the same thing. You need to figure out what you want to argue and make yourself a list. And keep that sheet of paper or that legal pad next to you so that as you go through the state's case and are cross-examining, you can check off what you need to get. Meanwhile, you got to have a second. You got to have someone who's taking notes. I know there are lawyers in here who can remember everything that's said. I know there are lawyers here who can take notes and ask questions at the same time. I was never that person. A law student will be interested enough to take good notes. And then you use those notes to prepare for your closing argument because those notes represent what, in fact, the jury has heard. A mistake that many lawyers make, young and old alike, is that they know their case so well that they get in front of a jury and they're arguing facts that they know because they read it in an offense report that the jury's never heard. So at a minimum, you draw an objection from the state, but at a maximum, the jury doesn't believe you because they didn't hear it from the witness stand. and you want to make that jury believe you. You know they already start out not liking you, right? And they don't trust you, and they're worried about you tricking them or getting your client off on some technicality like the Constitution, right? So you got to be right. You've got to argue what's in the record, what those jurors have heard. You want to make that jury be on your team. And they're only going to be on your team if they believe you and if they trust you. So when you're arguing to those jurors, attach it to the witness, describe how it came out so that those jurors recall the testimony, so that they believe you when you're arguing to them. Now, voir dire, I know this is about closing argument, but before you pick that jury, before you do your voir dire, know who you're looking for. Know what jurors you want. Have a picture of those folks in your mind, right? Do you want a bunch of men who are terrified about being accused of touching a child improperly? Do you want a mother of 3 teenage sons? Do you want a group of folks who know what it's like to be the subject of overreaching by law enforcement? Who do you want? And then set out to get them. When you're picking your jury, do a couple of scaled questions about whatever issue is important to you, so that when it comes down to it and you're making your selections and you're trying to decide between jurors,